Hello, I'm Henry Hendron at lawsurgery.com. Thanks for stopping by on this site. This is just a short video about what you can expect when you're in court at trial in a county court, the High Court or a tribunal. So first up, who starts? Well, the usual running order in a claim is that the claimant has to go first. This means that the claimant must unmask all its line of evidence before the defendant, because the claimant has the burden of proof in most cases. Depending on the course and the particular case, there may be opening statements, first from the claimant and then from the defendant. And this is basically a summary for both parties as to what they say the issues are and of the background. As a matter of good practice, I would recommend that you always prepare a skeleton argument prior to the trial, which you should submit to the court 3 days before the start of the trial. In that skeleton argument, you should set out in summary form the relevant facts. Don't go into a diatribe of everything, just the key relevant facts. And where necessary, if you know the law, put down the legal points to which you're arguing those facts. And then go on to say in your skeleton argument what the issues are and what the resolution should be from the court by reference to those facts. Say what you want. A good skeleton argument really can give you a running start at trial. So always prepare one and always submit it prior to the hearing, because the other side no doubt will do so. Right. So after any opening statements, the claimant must adduce its evidence. In a civil trial, the bulk of the evidence is contained in witness statements. Witness statements that are sworn by a statement of truth at the end. So what the claimant needs to do, or his representative, is to call the witness into the stand, who must then state his or her name and address, and then the claimant or his representative must take the witness to their statement, to where they have signed their statement and sworn it to be true and accurate to the best of their belief, and to get them to confirm that the witness statement in the bundle is their statement and that the contents of the statement is true and accurate to the best of their belief. Then, once they have done that, that witness statement is adduced into evidence, and the claimant can then ask that witness some further questions with the permission of the court. Now, a lot of judges are reluctant to allow questions from one side to its own witnesses, because all the evidence should be contained within the witness statements. But where there are gaps in those statements for a variety of reasons, the courts do and can permit the party to ask further questions of their own witnesses to clarify those gaps. So after, that's called examination in chief, by the way. But after we've done that, then it's the defendant's or the opponent's opportunity to cross-examine your witness. So your witness stays in the stand, and they have to then answer questions by the barrister for the other side. Now, those questions are usually short, they should be short anyway, short, sharp, snappy questions, and often in succession, one after another, firing away. The opponent in cross-examination is really tasked with getting the witness to either undermine their own evidence or to give evidence which is favourable to the other, to their clients. So it's their job to, it's not to be nice, but then it's not to be cross. Cross-examination doesn't have to be cross. But a witness really know their facts and really know their witness statement prior to going into the dock. Because if they don't, then that's when discrepancies arise, that's when they start to contradict themselves. And as soon as contradictions start to happen, well, that witness loses credibility. And in a civil trial where the burden of proof is on balance of probabilities, it all comes down to credibility. What is more likely than not to have occurred? And how do you determine that if you were never there or you were party to the contract? Well, you hear the evidence and you hear which witnesses are more credible than others, and on that basis you determine the liability. Well, that's only one of the bases. So moving on from the cross-examination, and we repeat that for all our witnesses until we finish all our witnesses, and then that is the claimant's case. And then it goes to now the defendant's case, and the defendant will do exactly what we have done by calling their witnesses, getting them into the stand, and then asking further questions where relevant, and then putting them forward for cross-examination. And then after all the evidence for the defendant was out, and that is the end of the case, and there will be closing submissions, where each party will make submissions as to the facts, as to liability, as to the law, as to whatever is relevant in that case. But that is the final opportunity, a very important opportunity for each party to have their say and to take the judge to important parts of the evidence, important omissions or slips, or to take them to where one witness has been particularly unreliable or has completely contradicted the other. It is the final opportunity to really make a difference in that trial process. When both parties have given their closing submissions, then the judge may give a decision there and then, or he may think about it and adjourn for half an hour or for many days, and then the judge will come back and give a decision. So that is the running order at trial in the civil courts.